My name is Evie Campbell, and this presentation is about the Indian Child Welfare Act, also referred to as Icwa. In this presentation, we will discuss the historical contents, MIFPA, the Tribal State Agreement, then Icwa. This presentation will take about 30 to 40 minutes. The objectives for this presentation is understanding the historical context of why Icwa, MIFPA, and the Tribal State Agreement was created, understand how Icwa is implemented, as well as understand how to apply Icwa to a case study. Out-of-home placement for American Indian children can be traced back to the boarding schools. At these institutions, children were told not to speak their language or practice their spirituality, and were made to change the way they dressed by cutting their hair and wearing uniforms. They were taught to be ashamed of who they were as indigenous people. There were several violations of international human rights law during the boarding school era. Universal Declaration of Human Rights was the first one, which includes the pursuit of life, liberty, and happiness. The International Covenant on Civil and Political Rights guarantees indigenous groups the right to enjoy their own culture, practice their own language, and use their own language. The third is the Convention of the Rights of the Child, which provides that when the state places children in substitute care, efforts should be made to preserve a child's cultural identity. And finally, the United Nations defines genocide as forcibly transferring children from one group to another. Out-of-home placement. In 1974, a national survey by the Association on American Indian Affairs found that about 25% or more of American Indian children were removed from their families and placed in foster care, group homes, residential schools, other institutions, or adopted. During 71 and 72 in Minnesota, 1/4 of the American Indian children under the age of 1 had been adopted, and 90% were in non-Indian homes. Due to these statistics, tribes wanted a law that would protect and put procedures in place to reduce the amount of Indian children lost to out-of-home placement and placed in non-Indian homes. In current statistics, the Minnesota Department of Human Services reported in '98 that minority children of African American, American Indian, Asian Pacific Islanders, or Hispanic race or heritage accounted for 39.6% of children in out-of-home placement. In 6 counties in Minnesota, the out-of-home placement rate ranged from 54.3 to as high as 85.1. 4 of the counties, Cass, Beltrami, Clearwater, and Mahnomen, were on or near Minnesota Indian reservations. During this same time in Minnesota, 11.1% of the children in out-of-home placement in Minnesota were American Indian, although they only make up 1.8% of the state's children population. Indian children in Minnesota are placed at an earlier age, have more multiple placements, and serve longer periods of placement. Legal implications. Tribal sovereignty. Tribes have inherent rights that were never lost. Tribal membership is a political status. It's not based on race or ethnicity. Self-determined policies gives tribes exclusive jurisdiction and decision-making power over their children. The Minnesota Indian Family Preservation Act was passed in '87 to strengthen and expand on Icwa. Minnesota took the federal law and made it a state law, whereby the state law imposes a higher standard of protection, meaning more children are protected. The federal law requires children who are eligible for membership to also be the biological child of member. The state law differs from the federal law by recognizing Indian children as those eligible for membership, giving tribes the authority to define its members. The Tribal State Agreement is another piece of legislation that was passed and was intended to address how Indian children could be cared for under the requirements of Icwa and MIFPA. The Indian Child Welfare Act authorizes states and tribes to form an agreement regarding the care and custody of Indian children and who has jurisdiction over these children in child custody proceedings. Agreements may also be revoked with notice to the other party. The main objective of the agreement is to set up procedures for county social workers and others to follow the laws. This legislation provided a framework for how to best care for Indian children who have been placed in the state child protection system. The agreement creates valuable safeguards to aid in the cultural consideration of American Indian children when they are removed from home and placed in the state care. Best interest of an Indian child. The tribal state agreements defines the best interest of an Indian child as a sense of belonging to a family, extended family, clan, and tribe. In this diagram, you will see that the child is at the center of what constitutes American Indian family, and support is given to that child by the parents, extended family, community, elders, tribe, and clan. They are all responsible for the care and well-being of that child. The goals of Icwa are to strengthen Indian families, protect tribal interests, and to keep decisions within the Indian community. Duties under Icwa: identifying Icwa children and promoting the rights of parents and tribes pursuant to Icwa. There are consequences for noncompliance of Icwa. Dismiss the petition and return the child unless this puts the child in substantial and immediate danger. Issues of noncompliance can be reported to Indian Child Welfare Program consultant at DHS. Noncompliance issues can also be discussed with the ombudsperson for Indian family, and there may also be malpractice actions against the attorney. Icwa applies when there is an Indian child and a child custody proceeding. Indian child. Icwa definition: a member of an Indian tribe or eligible for membership, and the biological child of a member. Children who have membership in a Canadian tribe do not qualify under Icwa. Tribes determine membership. Higher definition standard. Minnesota definition: member of an Indian tribe or eligible for membership, not enrolled. Enrollment is not always required to be a member of a tribe. For example, if you are a descendant, you still may qualify for services of that tribe, of your tribe. Child custody proceedings include foster care placement, pre-adoptive and adoptive placements, status offense disposition placements, which means illegal because of age, like smoking or underage drinking, permanency proceedings, termination of parental rights, which are now being referred to as customary adoptions for some tribes, third-party custody actions, and long-term foster care. Jurisdiction. Exclusive jurisdiction over children who are wards of tribal court, and tribal courts have exclusive jurisdiction over children who reside or are domiciled on the reservation. And domicile can be defined as where the parent lives or parents live. There is a general rule exception. Exception exists for tribes who are subject to Public Law 280. Public Law 280 gives state courts concurrent jurisdiction with tribal courts over children residing or domiciled on the reservation. In Minnesota, all reservations are Public Law 280 with the exception of Red Lake and Boyce Fort. Notice must be given to tribes when there is potential of placement, emergency removal, or court jurisdiction. Notice: no court hearing until 10 days after receipt of the notice, and notice could be sent by registered mail. Return receipt requested. If more than one tribe, notice to all tribes. If more than one tribe responds, then tribes will decide. Notice is sent to parents or Indian custodians and to Indian child's tribe. If tribe is unknown, notice is sent to the local BIA office. Parent is a biological mother, the biological father, married to mother, Indian adoptive parent, or an unwed father who claims that he is the father of the child. Indian custodian, an Indian person who has legal custody of an Indian child by tribal or state court order, or someone to whom temporary physical custody has been transferred by the parent. Indian tribe is a federally recognized tribe that are recognized and eligible for services provided to Indians by the United States government. Intervention: the tribe and Indian custodian have an absolute right to intervene in the proceedings at any point, and tribes have automatic party status. Transfer of jurisdiction to tribal court is mandated unless the parent objects, the tribal court declines, or good cause is found. 3 examples of good cause are child's tribe does not have a tribal court. A tribal court is defined as any administrative body. 2, parties are forum shopping, which means they are shopping for a better outcome. 3, undue hardship to the parties or witnesses, and distance alone is not considered good cause. Transfer of jurisdiction to tribal courts, the county remains responsible for placement costs. Emergency and non-emergency removal of an Indian child. Emergency removals, defined as necessary to prevent imminent physical damage or harm. Emotional abuse alone is not enough. Within 72 hours, must file a petition in state court, transfer the child to the jurisdiction of tribal court, or return the child. Foster care placement preference is used. Non-emergency removals. If there is not imminent physical damage or harm prior to the child's removal from the home, you must give notice, verify membership, determine jurisdiction, and get input in risk assessment. And in a non-emergency removal, you must provide qualified expert witness testimony that the child is likely to suffer from serious emotional and physical damage or harm if left in the care of the parent, as well as demonstrate that active efforts were used to prevent the placement and/or reunify the child with his or her family. The expert witness is defined in the tribal state agreement as a member in the child's tribe or has significant experience with child's tribe and knowledge and understanding of meaning of clan, relationship, and extended family, traditional and contemporary child rearing practices, traditional disciplinary measures used, ceremonial practices, medicine and traditional healing, and effective acculturation or assimilation in child's tribe. Efforts are different from reasonable activities and are defined as a rigorous, concerted level of casework that uses prevailing social and cultural values, way of life of Indian tribe to preserve family and prevent placement and reunify. Non-emergency removals. Can't do if the tribal court has exclusive jurisdiction. Foster care placement. The first one is extended family member. The second is a home licensed and approved or specified by the tribe. The third is an Indian foster home. And the fourth is an institution approved by the tribe or operated by an Indian organization. Adoptive placement preference. The first is extended family member. The second is other tribal members. And the third is other Indian families. Need good cause to not follow the placement preference. Good cause. A determination of good cause not to follow the order of preference set out is the Icwa should be limited to a finding by the court of one or more of the following considerations: request of a parent or a child of sufficient age, extraordinary physical, emotional needs of the child, unavailable ability of suitable families with the placement preference order. The court can reject request of the sole purpose if it is to avoid the application of Icwa and MIFPA. Permanency proceedings. Active efforts are always required. Qualified expert witness testimony is required. Notice, intervention, transfer of jurisdiction of provisions apply, and TPRs must be proven beyond a reasonable doubt. Voluntary foster placements. Notice must be given within 7 days. It must be signed by a judge, a written agreement, and a child can be returned upon demand. Voluntary TPRs, notice is required. Consent cannot be given within 10 days of birth. Can be withdrawn any time before entry of final order. And for up to 2 years after entry of final adoption decree, adoption may be vacated if the consent was obtained under fraud or duress. So consent means you understand the meaning that your child will be given up and you cannot get your child back. Changes of placement. Icwa applies to all changes in placement. Parents can petition for return of child if adoption is vacated. Here is a list of resources that these policies can be found under: the Indian Child Welfare Act, BIA guidelines for state courts, Minnesota Indian Family Preservation Act, Minnesota Tribal State Indian Child Welfare Agreement, Minnesota Department of Human Services, their Social Services Manual. This concludes our presentation. You have the option of taking the case study after this presentation, which is found on next week's agenda on the Moodle website. There will also be a forum set up for comments and discussion and or questions, and then no grade will be attached to this discussion. The purpose is to answer questions students have after viewing the PowerPoint presentation. Thank you.